Hi, I'm attorney Renee Osipov with Chelle Law, and we assist veterinarians with employment contract issues. Today, I'm discussing if a veterinarian can solicit clients after they have terminated their employment contract. And the answer depends directly on their employment agreement that they have previously signed with their employer. So, in a typical employment agreement, there's always a non-solicitation clause. The non-solicitation clause typically is enforceable for 1 to 2 years and just states that the veterinarian cannot solicit clients, employees, independent contractors, and sometimes even third-party vendors. So what does this mean to a veterinarian? If they were to leave their practice that they're currently employed at and either start their own or find employment elsewhere, they cannot solicit those parties for this specific period of time. But what does solicit actually mean? So typically it means that they cannot encourage, entice, reach out to any of those parties stated, including clients. What this does not cover, though, is if a client were to directly reach out to the veterinarian, they would not be considered soliciting that client. So if you are leaving a practice and one of your clients asks where you're going or seeks you out after you have left, that is not soliciting clients because they are coming to you. And so advertising can also be sort of a gray area sometimes. Typically, generally advertising on billboards, social media about your new employment status is not considered solicitation. You're only in danger of violating your non-solicitation clause when you are pinpointing in your advertising specifically your past clients. So this can even be sending out letters directly to those clients stating where you are going and asking them to follow you or to encouraging them in some way. So you always want to be careful. And then also included in a non-solicitation clause, I previously stated, are employees. And sometimes even a non-solicitation clause will say you cannot solicit employees or you cannot directly hire them for a period of 1 to 2 years. And this means that it goes beyond solicitation. You just cannot hire them. You have to wait until that time period has expired. So, like I said, you'll always want to refer back to an employment agreement to look at the exact language of what you can and can't do. But typically, non-solicitation clauses only include reaching out, encouraging, directly communicating with and asking clients to go with you. You certainly can let a client know where you're going if they're asking you. You don't have to refrain from telling them. And general advertising is typically okay. Again, you do want to refer to the non-solicitation. Sometimes in the non-solicitation or non-compete, there is language on advertising restrictions. So you definitely want to check that out as well. If you'd like more information, you can check out our website at Chelle Law, CHELLE law.com. If you'd like to contact our law firm for a consultation, our number is below listed in the description. Thank you.